All set.
Well, thank you, Jackie, and good afternoon, everyone. I am Amy Vasquez with the Employers Association of New Jersey. I'm so happy to be back here with you. This is my third presentation with you guys since November, and you're quickly becoming one of my favorite groups to speak with. Um, you know, for those of you who are on these calls, you know me. Some of you are EANJ members. But for those who are not familiar with Employers Association of New Jersey, I will give you my 30-second spiel, which is that we are a nonprofit trade association. Our members are employers located throughout New Jersey, all industries, all sizes. As I said, we have a number of YMCAs as members. And our mission as a nonprofit is to help good employers be better. So we spend a lot of time in the HR law compliance space, educating employers on things like wage and hour, which is what we're going to talk about today, but also discrimination and harassment, accommodating employees with disabilities, navigating paid family medical leave in New Jersey. So, it's things that as HR in New Jersey, you are dealing with on a daily basis, and we act as a support for a very low annual cost. I'll just put that out there. We do have 2 attorneys on staff. We do not provide legal advice per se, but we do provide information and guidance so that you can go forth and make good decisions when it comes to issues pertaining to your employees. So that's who we are and what we do. Since we were last together for the employment law update in November, a few things have happened. The most notable one, let me see if I can get my slides going. We had talked about the U.S. Department of Labor's proposal to increase the salary level test, right? So back in August of 2023, the U.S. DOL proposed revisions to the test that is used to determine an employee's status as either exempt or non-exempt under the Fair Labor Standards Act. The FLSA, of course, is the federal law that requires, among other things, that we pay our employees a minimum wage and that we pay overtime once the employee has worked over 40 hours in the work week, unless the employee is exempt from those rules, right? So the basic assumption is that all of your employees are non-exempt. Everyone is subject to minimum wage and overtime, but the law does allow for these limited exceptions from the rule, right? And it's always the exceptions where all the fun is, right? So these are typically referred to as the white collar exemptions. Sometimes you'll hear them referred to as the 541 exemptions, 541 being the area of the law, the section of the regulations where they're outlined, where they're delineated. Sometimes you'll hear them referred to as the EAP exemptions. That stands for executive, administrative, and professional. And when when a company wants to classify someone as exempt, the burden is on the company to prove that an individual meets all of the tests for a particular exemption. So in other words, if you don't want to pay someone overtime, that burden is going to be on the company to prove that they meet all of the tests listed for a particular exemption. So we could take a look at those tests. Specifically, there are 3 tests that must be met: a duties test, a salary level test, and a salary basis test. Again, all 3 of these have to be met in order to take advantage of an exemption. The first test is the salary basis. This pretty much requires that the exempt employee regularly receive each pay period a predetermined amount, which is not subject to reduction in any week in which they perform work, with limited exceptions. The concept here is that your exempt employees are not paid by the hour, right? They're not paid for the hours that they put in. Rather, they're being paid for the job that they perform. And their compensation cannot be reduced because of variations in the quality or the quantity of the work. Again, there are some exceptions to this, but the general rule is going to be that the exempt person is paid that same set salary every week, and then that salary does not fluctuate. So that's the salary basis test. The second test is the salary level test. In general, the salary level test is the simplest and most straightforward of the three tests. Essentially, is your employee earning at least the minimum salary level? This is what's going to be increasing come July 1. And the final test, and we're gonna get into those details. And the final test to be an exempt employee is a duties test, right? And that's where we see the outline for those three main white collar exemptions: executive, administrative, and professional. Which of the tests you look at for any particular job is you're typically going to determine it based on the type of work, for that job. So for example, if you had someone who regularly manages 2 or more employees, you're going to be looking towards the executive test. If you had someone who was working for you who had an advanced degree that they're typically obtaining through prolonged education, you're likely going to be looking at the professional exemption. For our purposes today, we're really not going to do any kind of a deep dive on the duties test. Nothing is changing with regard to the duties, right? The duties test is remaining exactly what it has been. The salary basis test is remaining the same. The big news is all surrounding that minimum salary threshold. And I will just sort of sidebar here a moment and say that in New Jersey, we have our own wage and hour law, right? Because we are very special here in New Jersey. We always have we always go above and beyond, right? We always have extra. But when it comes to exemptions, New Jersey has adopted the federal regulations verbatim. So when these new rules take effect, they will be the rules that the New Jersey Department of Labor looks at as well when they're determining exemptions. So currently that salary level to be exempt is set at $624 per week, which you can see annualizes to just over $35,000. Beginning on July 1, that salary level is going to increase to $844 per week, which is the equivalent of $43,888 per year. And if that wasn't enough, on January 1, 2025, we will see it increase again to $1,128 per week, or $58,656 per year. So that initial bump, right, between now and July 1 represents just over an $8,000 increase. And then the second bump is close to a $15,000 increase. So all in, by January, we are looking at $23,000 increase in order to maintain an exemption, which if you have someone who was only earning that current $624 per week, that would represent a 65% increase in their pay, right? So let that sink in, because that's pretty incredible. So what does this mean on a practical level, right? It means that come July 1, and then again on January 1, if you have employees who are currently classified as exempt, but they are not earning these new thresholds, they will become non-exempt unless you take some action. So, here in New Jersey, relatively speaking, we are a state that has a fairly high cost of living, fairly high salaries, but with that being said, this could potentially hit some employers harder than others, especially when we look to our nonprofit organizations, such as our YMCAs. You want to consider maybe you have a current exempt employee who's they're earning more than that minimum 35,000. Maybe they're at 45,000, right? Currently, a decision is going to have to be made as to how you treat them going forward, right? Do you give them a $14,000 raise? Do you reclassify them as non-exempt and start paying overtime? Do you reduce their salary to make up for the fact that you now have to pay them overtime? Well, we'll talk about some of these options in a bit, but clearly, in order to maintain the exemption, some action is going to have to take place. And my last row on the chart here outlines what will happen in 2027 and beyond. Because the regulations contain this automatic update provision, so that every 3 years, these numbers will be reviewed and brought up to date. So these numbers are based on the 35th percentile of earnings for full-time salaried workers in the lowest wage census region of the United States, which is currently the South. So when it gets reviewed again in 2027, they'll be looking at what those numbers, where those numbers stand at that point, and then they'll be making the adjustment to this salary level from there going forward. Now, the last time the Department of Labor proposed this automatic update provision, it was under the Obama administration in 2016. It was highly controversial. It was challenged in the courts, and I very much expect that this new rule will face a similar challenge, right? Different groups claim that the Department of Labor is exceeding their authority by putting in this automatic update provision. So, we'll stay tuned. We'll see what happens with that. Of course, we always get information out to our members to make sure that, any changes you're made aware of. But as of now, this is all scheduled to move forward and, take effect. What are we in May? So, a month and a half away. In addition to increasing the salary level test for the EAP exemptions, the salary threshold to be a highly compensated employee is also increasing. So just a very quick refresher in case you're unfamiliar with this exemption classification, the regulations state that someone who earns this high of a salary, it's currently set at $107,432. They're earning that annually. And they customarily and regularly perform any one or more of the exempt duties of an executive, administrative, or professional employee will qualify as exempt. So the thought here is that someone who's earning this high of a salary that's going to be a strong indication that they're exempt, right? And therefore, we don't have to go through all of the duties tests. We just need to make sure that they can check the box on, one of the listed duties for any one of the particular duties tests. So this is just an alternate test that could be used to classify someone as exempt if you had people that were earning, at this high of a rate. On July 1, we see the number increasing to 132,964. And then on January 1, 2025, it increases yet again to 151,164. This salary level is set at the 85th percentile of full-time salaried workers nationally. And these phased in increases, both for this highly compensated employee, but also for the regular EAP exemptions, the DOL has said this is sort of their way of easing employers onto it, into these new numbers, instead of doing it all in one lump sum. I guess they kind of thought maybe they could lessen the blow a bit if they implemented it in increments. I'm not sure if it lessens the blow, but so currently, if you are relying on this exemption for some of your employees and they earn anywhere between the current 107 and the proposed or, soon to take effect 151, you'll need to decide what you're going to do with them going forward. So we have some options, right? I've listed out a few of them. There could certainly be other options. I don't mean this to be an exhaustive list, but these were just ones that came to me that I thought you might want to consider if you have employees that, fall into this group. So the first option would be to increase that exempt person's salary so that they are now at or above the new thresholds. This might be a good option if you currently have exempt employees that are very close to the threshold, because maybe it's not going to be that big of a jump for them, right? For others, it could mean giving significant pay raises, and that may just not be feasible. And then you also need to think through, what are the ripple effects of this option? Say you have a manager who's currently earning $50,000 and their director is earning $59,000. So if you bring the manager who you want to keep exempt up to the new salary level of 58,656, they're going to now be making almost as much as their boss is making, right? So we see this opportunity for salary compression. Maybe for some, if we do end up increasing the salaries, maybe we also increase responsibilities, right? It's just sort of a way to help justify the increase. Again, just something for you to consider. A second option here would be to convert the employee to non-exempt and pay them for the overtime, the hours that they work over 40 in the work week. So there's considerations here too, right? Because as an exempt employee, you may not have been tracking their time. You don't know their hours. They're exempt. There's no requirement to track the time on an exempt person. As I said, they're paid for the job that they perform, not the hours that they put in. So now they're becoming a non-exempt employee, and the burden is on the employer to keep true and accurate records of all time worked, and then to properly compensate them for those hours, including overtime if they do go over 40. Another thing for you to think about here is now you also will need to decide how you're going to pay them, right? Will you keep them salaried, or will you transition them to hourly? Either one is fine, right? Either one is permissible, but you'll need to figure out what works best for your organization. If you opt to keep them on a salary, you'll want to consider what that salary is intended to compensate them for. So, for example, when they were working for you in the exempt capacity, they got that same set salary regardless of the number of hours worked. But now we have to be mindful of the number of hours worked to determine if and when overtime is due. So is their salary going to compensate them for all hours worked up to 40 in the work week? Is it going to compensate them for 35 hours or 37 and a half hours? Will you set the salary so it is intended to compensate them for all hours worked in the work week, with the understanding that you will still owe overtime when they work more than 40? Again, all are permissible, because with your non-exempt employees, you can pay them on a salary. It's just that they are overtime eligible, right? And these might be employees that are currently on a salary that are transitioning to hourly. So there's just things to think through. If you do convert them to hourly, administratively, this is likely, clearer and more straightforward of the options. But that could be a tough pill to swallow, right? For someone who was previously exempt. Oftentimes our exempt employees, there's in some organizations, like a status that goes along with being considered exempt, and they're paid a salary. And, that might be sort of a morale issue to now pay them on an hourly basis. So again, just something to think through. Other considerations that come up with this option, some organizations tie certain benefits to exempt or non-exempt status. Maybe exempt employees earn vacation according to Schedule A and non-exempts according to Schedule B. How are you going to reconcile this for employees that you're switching over? Option number 3, you may decide to reclassify employees as non-exempt and then manage their time so that they don't go above that 40-hour threshold. Again, the idea here is that their salary will remain the same because you're not going to have them working over 40 hours in the week, which is great if you can manage that, right? Because the problem is, how does the job get done? If these were employees that are typically working 45 hours per week, that's likely because that's what the job warrants. So it could mean hiring additional employees, subcontracting out some of the work, which obviously both have their own financial considerations that go along with it. If you do classify, option 4, I should say, would have you classify as non-exempt, track the employee's hours, but lower their weekly salary to make up for the fact that you now have to pay them overtime. So again, I think this is going to be one of those tough morale pills to swallow for many, right? No one wants to have their base salary lowered, but because they are now overtime eligible, overtime is at a rate of time and a half, they could have the opportunity to end up making close to what their original salary was if you anticipate they'll regularly be working more than 40 hours in the work week. And finally, the fifth option that I've outlined is to consider some other compensation methods. Some employers, you may use non-discretionary bonuses and incentive payments, including commissions, to satisfy up to 10% of the standard salary test. So that is something that may or may not work for you. But, the bottom line is I think you want to try and model out various compensation plans, determine the costs of increasing salaries versus the cost of reclassifying, versus the cost of coming up with a whole new compensation method that maybe incorporates bonuses. There are options, but what we're kind of closing in on the time. So now is the time to be thinking all of this through. Whether there ends up being an injunction that stops this all from taking effect, that could happen. That is what happens in 2016. So, I don't think it's good advice to do nothing and bank on that. I think you want to be ready to move come July 1 in case this does in fact move forward. So again, this is just thinking through what your game plan is. July 1 is less than 2 months away. And you want to have a sense of who is your at-risk population. Pull together a list of those employees that are currently classified as exempt, but they're earning less than the new salary threshold of $58,656. Or, less than that highly compensated employee exemption if you're using that exemption. How many employees are you talking about, right? How close are they to the new threshold? Do you have a sense of how many hours they typically work, right? Because you might not, because you're not tracking it currently. Do these employees work from home? Are they checking in on mobile devices? All of this gives you a sense of your exposure in all of this. Are they in fact meeting the 2 other tests, right? Because this new regulation it's sort of a nice opportunity for us to, audit our own classifications. Do we have people that may not be meeting the duties tests and probably should be moved over to non-exempt? This kind of provides a nice opportunity to do that. Take a look at your job descriptions. Are they current? Do they accurately reflect the job that the employee is doing? Are your internal decision makers aware and have an understanding that these new regulations are coming? Ultimately, leadership will need to be aware because they'll need to consider budgets and whether they're going, what's going to happen here. And then there is that morale issue that I mentioned. As I said, many employees view being exempt as having this certain prestige associated with it. So, even though they're overtime eligible and we think that's a great thing, right? They might not think it's a great thing. So, stay tuned because I think that it is very likely we will see these challenges. you know, we'll see how it goes, but I don't think it means that you do nothing and take a wait and see approach. Rather, I think you want to, you know, start looking at these things and plan to move forward with plan A, whatever you determine plan A is. But perhaps we have plan B in mind in the effect that this is stopped from going through. But right now it's all green lights, so we should be prepared. Just a few other quick things I'm gonna touch on before I turn it back over to Jackie. In other wage and hour US Department of Labor news, at the end of April, the Department of Labor published a guidance document regarding the increased use of artificial intelligence and other automated systems in the workplace, specifically with how they relate to compliance with the Fair Labor Standards Act and other workplace standards like the FMLA, the Federal Family Medical Leave Act. And the DOL acknowledges in their guidance that these AI systems are an incredible way to streamline tasks for employers. They improve efficiency, they can improve safety, enhance workforce accountability. However, they point out that without responsible human oversight, the use of these technologies may pose potential compliance challenges. So, for example, there are some AI tools that have the ability to measure and analyze metrics of worker productivity or activity. You know, maybe they're measuring keystrokes or mouse clicks, but relying on those programs alone without human oversight could lead to FLSA violations for not properly compensating employees for all hours worked, right? So the metrics that are being tracked by these AI systems should not be a substitute for the analysis of whether an employee was suffered or permitted to work during that time. You know, that is the language, that is the standard that the FLSA uses. And just because we're using this incredibly, you know, this emerging and kind of amazing technology, you know, this is sort of the DOL's reminder that, well, hey, our laws haven't gone away. So you need to make sure that if you are implementing these types of practices, that you remained mindful of your obligations under the laws that they enforce. You know, same thing with break time. The DOL's guidance discusses how some timekeeping systems now incorporate AI to make predictions and to auto-populate time entries based on a combination of prior time entries, you know, regularly scheduled shift times and breaks times, and other data. So they, you know, they call these smart entries, but again, they don't relieve the employer from the obligation to ensure that the records are true and accurate and reflect what the employee actually worked. With regard to the FMLA, employers need to be mindful of automated systems that process leave requests, right? Determining eligibility, calculating available leave time, you know, whether leave is for a qualifying reason. All of these could create these potential compliance challenges if they result in leave being incorrectly denied. So my bottom line here is that when employers are using or considering implementing these AI technologies, you just want to be mindful that all of the laws still apply. The DOL stresses that proper human supervision is necessary. And, you know, regardless of the technology or the platforms you're using, it is the employer who ultimately needs to ensure compliance. And finally, I will just wrap up. Just a brief word on each of these because I do realize I'm up against the clock. When we were last together, we talked about the newly enacted Federal Pregnant Workers Fairness Act. The EEOC has now published their final regulations, which are meant to clarify to workers and employers who is protected by the statute, and how what their interpretation of the statute is, right? And how they will be enforcing the statute. So notably, the regulations require employers to provide accommodations to employees who have had abortions, which, as you can imagine, is a highly controversial provision. Less than a week after these final regulations were issued, Republican attorney generals from 17 different states filed a lawsuit challenging the legality of these final regulations, specifically claiming that the regs go beyond the scope of the statute itself and that they fundamentally infringe on the sovereignty of the states, because some states, as we know, have prohibited or limited abortions. So where does this leave this, or where does this leave us? For now and until a court holds otherwise, employers are obligated to comply, but certainly stay tuned and we will see how this holds up. My second bullet point, the EEOC has also updated its guidance on harassment in the workplace. They have clearly been a very busy agency. This updated guidance outlines the agency's legal standards and potential for employer liability for harassment according to the federal anti-discrimination laws. According to their data, harassment remains prevalent, right? And their guidance here, it's not new and groundbreaking, right? This is the first new guidance document the EEOC has issued in 25 years. But it's sort of takes things that have happened in that period of time and kind of pulls it all together nicely in one document. And it's framed through the lens of recent events, right? So the Me Too movement, gender and LGBTQ issues, issues surrounding remote work and digital media. Their guidance is just that. It is guidance. It is not legally binding, but it does provide us with insight into how the EEOC will treat harassment claims going forward. And finally, you may recall the last time I was with you, we discussed the new employer reporting requirements for unemployment purposes, right? There was a change in the unemployment compensation law that requires employers to electronically submit information regarding every separation from employment, regardless of the reason and regardless of whether the worker actually files a claim for unemployment. The New Jersey Department of Labor has proposed their regulations on this requirement, but they have not yet been finalized. So they're sort of in that finalization stage now. I'm also told by the Department of Labor they are working on building the back-end infrastructure for this to take place. So this is another one of those areas where we can sit tight, right? When that becomes available, we'll be getting the word out, and we'll wait and see. So that is what I have for you. I am very happy to hang around. I'm very happy to take questions. I know you probably have more meeting to get to.
Hi, Amy. This is Fran Reer from the AMC of Newark. I was wondering if I could ask you a question and also hopefully a quick request. Question is related to the options, the employer options for exempt employees. To avoid discrimination, should employers apply one option to across the board if they decide to select one of those options?
So I think that you have a degree of flexibility. So exemptions are determined on an individual basis. But if you had a group of employees that were doing the same job, it might be worthwhile to look at all of them. Ultimately it comes down to, do they meet the test? But if you start treating people that are essentially the same in terms of, the exemption criteria, their salary, if you start treating them differently, that could potentially open you to a claim of discrimination.
Thank you. And the request, I was wondering, would you be able to talk a little bit about the new final rule on independent contractors versus employee status?
That is an entire seminar unto itself. I mean, I could, but You know, the thing that I do say about that is because we are operating here in New Jersey, the New Jersey standard is so much more strict than the federal standard. So I know there's a lot of news surrounding the federal standard, but it's already practically impossible to classify people properly as independent contractors in New Jersey. And New Jersey uses that ABC test that's pulled from our unemployment compensation law. And it's a hard test to meet. It is a hard test to meet. And you know, because of New Jersey's wage theft law, the consequences of getting it wrong are really high. Our wage theft law is touted as the strongest in the nation, the highest penalties. So, you know, yes, the federal is getting all of the news and the attention right now. My only caution would be is like, we've already are dealing with so much of a stricter of a standard, in my opinion. So, and we will have EA&J is going to have programs on that in the fall.
Thank you. That was helpful.
Any other questions for Amy? All right. Sounds like you're very thorough and there are no questions.
No problem. My email is up on that last slide, amy@eanj.org. Please feel free to reach out. Those that are not members, I would love to talk to you about becoming a member. So, you know, please feel free to reach out on that as well. And thank you for having me. I truly always enjoy speaking with this group.
Thank you for always being available to speak to us. We appreciate you and the information that you share with us so much. Thank you.
Welcome. Thanks, guys.
All right. So, I know we're all busy preparing for camp. Are there any things on anyone's mind that we want to kind of chat about? Anything we're doing differently or looking at this season?
We were last night, our senior director of child care and camp indicated that for 2024 that it's been waived, the fingerprinting.
Yes, we did get similar information as well. It will not be implemented. It seems it's not off the table, but you know, for this coming camp season, it looks like it's not going to be necessary, as well as removing the off-site field trips as a high-risk activity. That was also part of the language. So we'll see. We got to keep our fingers crossed and hope that it stays off of their requirements.
Jackie, were you notified by the New Jersey Alliance, or how were you notified?
Our CEO was notified by the Department of Health.
Okay, thanks.
Are you local Department of Health, Jackie?
I'm not quite sure. I will assume that might be the case.
Has anyone else heard that? I haven't.
We did as well. Our CEO also received notice from Department of Health, and I think the operative word was essentially so far. So let's see what happens in future. If it's currently on hold, but I guess after further examination, they could go back to square one and start again with fingerprinting.
Mm-hmm.
Is that for all of it or just, so my understanding was if you're accepting vouchers? the childcare subsidy vouchers, you still needed to fall under that, or depending upon what license you ran your camp under, that you still may need have a population that needs to be fingerprinted.
So the
what
language that we received from it's actually the state Department of Health that we received notification of, and it simply states, as a result of the forthcoming adoption, does not implement the fingerprint criminal history record checks and does not make the rules applicable to municipal youth camps. So it doesn't really speak to the subsidy piece, which is what that was attached to. So I'm
Yeah.
assuming that it is. Which is a relief, right?
Jackie, can I
Anything?
ask a different question? With summer camp coming, you know how we have to post for minors, their scheduled hours? Isn't that supposed to be updated on a weekly basis? And is it for their hours for the upcoming week?
We do it for the upcoming week, and then we do ask them, like on a hard copy, we keep it in the offices to change it when there's changes that happen, almost like in real time, because changes happen like in the minute, right? Not even in the week, in the minute.
Okay, because I'm not sure we're so good with changing the hours from week to week.
I think if I went back and looked at it and did a comparison to payroll, we would probably find some gaps.
Yeah, okay. I was just curious to see, you know, are people truly changing it every Monday?
So if I can jump in real quick.
Please do.
Please do.
So, you know, the purpose of posting the minors' hours is because minors are required to take breaks after certain periods of time, and then there's limitations on how many days they can work consecutively and all of that. So by having it posted, the idea is that, you know, anyone could see it and say, well, wait a minute, why isn't Joe taking his break? He's going on hour 7 of working. He should have had a break. So that's sort of the idea behind it. I always thought, and I can confirm this with the Department of Labor, but my understanding was that you were posting for the current week, right? Because that goes along with someone seeing it and saying, you know, that they've worked too many hours or whatever it may be. But I can follow up with you on that, Maureen.
Okay, yeah, I mean, I think our typical practices, you know, we schedule people from point A to point, you know, Z, and we've got a break scheduled at this time, but is it actual? That's kind of hard. I mean, we try to stick within those parameters, and so I find what we stick up in June tends to be what's hanging up there in August.
Right. And if that, I think that, you know, do you have them punch out for their breaks?
We do.
Yeah, so it's the time record that you're using to pay them. And you know, it probably, as long as it's fairly close to, you know, it's really that 5-hour mark with getting a break. That's the key thing for minors.
Okay, thank you.
Anything else on anyone's mind that we want to kind of throw out to the network? All right, well, I think we got 10 minutes back on our busy schedules. If there's nothing else.
Jackie, actually, I
Okay.
just wanted to say something. Thank you for sending out, you know, the link to register for these classes. But there is a known situation at the Y of the USA, depending on who you speak to. You can register for the class, but the actual credit for the class is not being totaled into the cumulative credits. So I'm going to reach out again to them, but it's been an ongoing situation. So if you are looking for credits for your leadership certification, you may want to just kind of add up where you're at to make sure they're included.
Thanks. I was not made aware of an issue.
It may be a New Jersey based issue. I don't know with how they're registering. It's like been told that if you register, there's something that has to happen on the back end, and it doesn't seem like it's happening. I don't know specifics, but when I find out more, if I can, I will share with the group.
Great, thank you for that. Anything else for the good of the order? No? Well, thank you guys so much for taking time out of your busy day to join us and learn more about the crazy updates that we have. Kathy, did you want to say something?
No,
Oh,
thank you.
okay.
Just gonna say goodbye.
All right. Well, thank you so much, everyone, for joining us today. And I will be posting up the recording on our YouTube site if you need to refer back to it at any point.
Thank you for organizing.